What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with the final part to day 14. So to summarize, this day is kind of difficult because, as always, Darrell is all over the place. So he tries to play nice, especially with the jury. He's trying to seem as if he's like a semi-normal person. There's actually a part where he completely takes off his mask and he's, for whatever reason, giving them a better look at his face, which I was pretty happy about. His closing argument was absolutely ridiculous. I was hoping that he wouldn't get the chance to. You all will see what I mean pretty soon, but it's bad. Oh man, and then we have a couple of moments where he tries to be friendly towards the judge. He tries to act as if they're pals, and I cannot stand when he laughs. His laugh is horrible. When he laughs, when he tries to act like, oh, we're connecting, we're just pals. No, just go to prison. We don't want to be pals with you. But I don't want this intro to be too long, so I just want to say thank you to a couple of people that donated. Thank you so much to April Smith for a $5 donation. I really appreciate it. And thank you for continuing to watch along and for sticking with me. And last but not least, thank you so much to Ty Tyler for a $15 buy me a coffee donation. I really appreciate it. And thank you for continuing to watch along and for sticking with me as well. And most importantly, nobody has to send me a single thing. What I will say is, if you would like to donate to the community of Waukesha, there are links pinned at the top of the comment section. So if you're looking for resources to give back to the victims and the community, they're right there for you. And since we're pretty much at the end of this series, I do want to say thank you to every last one of you, and I hope you enjoy the video.
I need it quiet in the courtroom, please. We are back on the record.
And we're back again.
As they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom, and during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. Right. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law.
Okay, and sorry to pause so early on, but the fact that this is about to go in the jury's hands is what's making him so desperate right now. Like, it's to the point now where I don't even know if she could say 5 words without him interrupting and screaming subject matter jurisdiction. He pretty much understands it's over. I mean, the fact that he keeps saying, I want to make an offer of proof for my appeal, it's weird because there's no decision that's been made yet. He hasn't been proven guilty, which we know he's guilty, but it's like, the fact that he's saying that he understands that he's going to be found guilty. And he's even saying that to everybody before we get to the point where the jury even makes a decision. So it's just all insane. But yeah, he's on his last leg here. This is like peak desperation.
That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings.
Oh my goodness, that was perfectly said. That was perfectly said. And I love the fact that right here near the end, she is making it so clear to him. I see right through you. I see exactly what you're trying to do here. You don't want to go to prison, okay? But we're going to get you there. We're going to make sure that you have a nice, comfortable, hopefully it's not comfortable. We're going to make sure that you get there. We're going to get you to where you need to be. I had a point I was going to make, which was, okay, never mind. I literally forgot it in the middle of saying that, but we'll just let it play.
I've said it before. I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant, but they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there. Other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. and she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum.
This is the creepiest thing ever to see them pan over, and he's just standing there facing the other way. This is going to be the thumbnail, though. So, okay, you guys are seeing it once again. That's going to be him in the thumbnail. That's very creepy.
That when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present
What is that?
In this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly.
All right.
Attorney Hopper.
Your Honor, two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head. They've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay, but one thing I was just going to say really quick, it's insane how much they have to put on the record simply because he likes to play this game of, you guys are hiding certain things from me, or you're making it to where I can't see, because he's such an opportunist that he would say that, that entire time they were showing that exhibit, I wasn't able to see it. They weren't allowing me to see it. It's just wild they have to put so much on the record just because of that reason. I mean, I'm not sure if this was, this situation is pretty unique, I would say, like to have to throw the defendant in the other courtroom, I'm guessing, but it's like, yeah, I noticed that, like, whenever they put him in the other courtroom or whenever they're doing something along these lines of showing an exhibit, they have to overly explain, like, okay, I'm doing this for this reason, Yeah.
Thank you.
If you would like, before the jury comes out, we could do a test,
Yes, could we please?
please.
Which I'm glad they explained it all, so he can't get out of it.
Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again,
Nice.
I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them.
Oh boy, she's gonna unmute
And are
him.
you turning off the, all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
Here we go. It's like when he's pacing back and forth like that, you can see he's trying to think of something.
Okay.
And I'm sure he's thought of a couple things here, so. Yep, we're gonna hear what Darrell has thought up to argue about. Like he's literally brainstorming right there. He's looking behind him at something that he's gonna bring up here in a second. I'm so sure of it.
All rise for the jury, please.
All right. By the way, I hope everybody is doing great. I hope you're all staying safe out there. Thank you so much for tuning in for another video. I'm hoping that I get this one out pretty quickly, so yeah, just thank you all so much for all the support, all the love. I really, really do appreciate it, so thank you.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
Here we go.
Madam Clerk, if you would please turn on the PowerPoint. Yes.
I know this is gonna be amazing. I'm trying to remember if
Hold on
I
one
heard it
second.
already or I'm
Mr.
guessing
Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opera, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opera, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection.
Who cares? Can we please mute him?
May continue.
Let's just mute him, in all honesty.
Not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do.
Oh my goodness, this is ridiculous. I don't understand why he's even unmuted. I mean, given the way that he's been this entire time, at this point, he has not earned the right to be unmuted during the closing argument because he's just going to pull antics the whole time. You see, he has an objection with every single thing, and none of it has to do with him saying, hey, I didn't do any of this stuff. It's just, oh, it's not 77, it's 76. Wow. Man, you should just go free, shouldn't you? Okay.
I apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got some.
Count 4, Jane Kulik.
Thank you.
Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful.
I remember this.
To you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution.
Right.
And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The Extreme Dance Team. It's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the Extreme Dance Team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the Extreme Dance Team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The Dancing Grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life.
Absolutely.
I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Okay, and sorry I'm interrupting. It's really crazy that it really is that simple. He could have just stopped the car or the SUV and none of this would have had to happen. So this completely proves this is all that he ever wanted, was to hurt as many people as he possibly could. But okay, I'm not going to keep us paused here.
Excuse me, Attorney Offer, your objection, sir?
Here we go.
You specifically, I'm sorry, can I be heard?
Your objection, sir?
Oh, I didn't know if I was on mute or not.
You're not.
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Opera. Your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how
Opera.
can
Can we just mute him?
to what was saw? if
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Opera.
Okay. We're at a point right now where it's like, ever since she said, it all boils down to he could have just stopped. Like, I'm still kind of stuck on that. And it has me in disbelief that, like, he's actually fighting this right now. Like, I'm still stuck on that. I don't I don't know why. But it's like, now I'm just in disbelief right now that this is even a thing, that he's, like, actually trying to get out of this. I mean, we're at the end of the trial right now, so I shouldn't even be thinking in this way because he's done it consistently. He's trying to find angles to get out of this, but it's like, this is just, it's insane. Yeah.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life.
Right.
If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanner's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop. Anywhere along the way, one of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route, at any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident, it wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play.
Oh boy. Another cowardly display. This really shows what a coward this dude is too. This is ridiculous.
The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we gonna mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted. It's overruled. You may continue.
Why is he not muted?
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and the hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia walking with Burris Logistics, keeps going, plows through the entire Extreme Dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the Steaming Cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the Steaming Cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They looked like bowling pins. And when she saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh my God. Oh my fucking God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they're supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may
It's,
continue.
I would argue that it's,
Attorney Hopper.
I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to...
Please mute him.
Don't follow
Please
me.
just go ahead and mute him.
I move
Exhibit
for a
1.
mistrial.
Exhibit 152.
What did he say? Did he just say I call for a mistrial?
Made my ruling. I'm going to mute you if you don't follow the rules.
Exhibit
I'm
1.
mistrial.
Absolute
Exhibit
clown.
152.
You're going to prison, dude. No mistrial.
Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Bidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, States Exhibit number 130. Put that up here quickly.
Yeah, this is insane.
Thank you.
It's infuriating.
I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right?
It's actually very
stalled
true.
him from keep running. Kept him in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car.
Look at this clown.
Same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos.
Exactly.
And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him.
That is so stupid. He
So
kept
this
it.
entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry. Your objection, sir?
Mischaracterization.
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
you're
that.
No, you absolute clown. You absolute clown. She cannot tone it back. These are closing arguments. This is the dumbest thing. Like, he's still playing this game of, oh, my feelings are hurt. You're not supposed to be talking to me in this way. It's a closing argument. The gloves are off at this point. I mean, she didn't have to talk to him gently to preserve his ego to begin with. So it's just ridiculous. But I'm glad that I hope she uses the word shenanigans about 30 more times before she ends her closing argument here.
Objection is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. The Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions.
Absolutely.
Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence. Use the map. 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please.
Oh boy, this is gonna be rough. She put that perfectly. He cowardly drove
Go ahead.
through a bunch of people. That's exactly what he is at the end of the day. Like, the guy is just a coward, man. Even the way that he goes about, like, you see it all throughout the trial. The people that he tries to impose some kind of, like, fear, or he tries to make them fear him when he has no ability to do anything. He's literally an inmate. Whenever he sees somebody like emotional on the stand, those are the times where he tries to get the most aggressive. Like, it's just a bunch of predatory stuff. I guess they're not going to play up with sound here. And I still haven't seen the video yet of him actually, like, driving through the parade. I feel like that's going to be way too much. Like, even the times where they just play the audio of what happened, it's too much for me to even listen to. Like, it's just sad. Like, do you see this right now? This is actually getting me aggravated. I hope so very badly that this dude is in prison having the worst time that he could ever have. Like, I hope that it is just the most stressful time that he's ever gone through. I don't usually talk like this, but I hope so badly that right now he's just sitting in prison and he's like, man, I messed up completely. Like, I just want him to feel that, because you sit here and you're looking at his face, he's looking at what he did, no emotion. Like, look, I'm gonna go back here just a bit. Hold on. That right there, he's not looking away. He doesn't show any visible, like, shame across his face. He doesn't feel weirded out by it. And you can hear family members in the background crying. No movement. The only thing he is bothered right now he's bothered about in this situation is the fact that he is here right now. He's not allowed to go free because he just feels like he should be free. Absolute clown, Fisher Price attorney, dirtbag. I feel like the Fisher Price attorney thing, it doesn't even fully, like, they, even though he's a terrible attorney, I feel like it doesn't capture like just how messed up it really is. So I feel like just saying he's a dirtbag, that's more fitting to me. But all right, I'm just gonna let it play. Like, even Judge Darrell is...
Thank you. Before we continue with Mr. Brooks's closing arguments, I'm going to take a short break. All rise for the jury, please.
Man, that is...
Am I muted?
No.
All right, I don't even want to hear his voice right now. But it's like you could even see... And you see right here where I paused, Judge Darrell is just not like that. We didn't even see the video just then, but you can tell based on the emotions of the people that were there, even Judge Darrell, the sounds we're hearing, that it's just as insane as like I'm picturing it to be in my mind, because I haven't seen it yet. But oh man, I do not want to hear what he's gonna talk about, because all it's gonna be is, why are you guys hurting my feelings right now doing all of this stuff? Dude, just get in the cell.
The jury should know that they can nullify.
You are muted now.
Perfect.
Thank you. We'll be in recess for about 10 minutes.
Yeah, just like I thought, even after all that, even after the fake little prayer that he did there, still, oh, just so you know, you can nullify whatever he was gonna say. I'm glad he got cut off. But, okay, I'll go ahead and skip over to this inevitable clown show that he has waiting for us. So we'll be back in just 1 second. There's no sound yet, just in case you all can't hear it either. But okay, so he's in this courtroom now, which means he can't be muted. But we know there is a clown show waiting, so.
The record should reflect that Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Oh my goodness, this is insane. This is giving me like a short fuse now. I have such a short fuse at this point. It's like after the closing argument and then he comes back and it's right back. It's no change. Nothing has changed. It's right back to it. And it's like, I don't even want to hear this stupid stuff. It's like she invited him back in here and he's just going to get kicked out again. He really came back just to do it again? Okay. I'm not going to keep it paused.
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document, as it is not based in lawful law, and it does not prove subject matter jurisdiction whatsoever.
He didn't even read
It
it.
refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor?
What is he talking about? At this point, it's...
Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record to reflect, the jury is coming out.
I love how nobody is speaking. He's literally the only one repeating his nonsense over and over. But a few of you in the comments mentioned this as well. It is good that the jury, like, it's good that they get a glimpse into just how crazy he is, like how crazy he can be, especially at his worst.
Thank you, everyone. Please be seated.
So thank you for reminding me of that. I do need to remain
Go ahead,
aware
sir.
of that.
You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument.
Okay, so a new game has started. So now he saved that just for when the jury was coming out. So now the jury is here and he's going to say, I never said I had a closing argument. Why are you rushing me? Do you see this, jury? She's she's being biased. She's not letting me, like, this is so ridiculous. And he thinks this is gonna pull at the heartstrings, and this is really gonna get them to go, oh, well, we gotta find him innocent then. You're rushing him. Why are you doing that, Judge?
The jury, please start.
Dude, get in the cell, dude.
Of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
That's good work. No closing argument for you. Your clown show is doing exactly what it's supposed to. I'm sorry if I'm coming off a lot more aggravated in this, but it's just, man. The prosecution's closing argument where they brought everything back to the forefront about like what we're here for, it's rough.
Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bajurkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
Nice.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a
He
judicial
won't allow her to
determination
do it.
that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able
that
to
ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And
arguments.
you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again. The time
I
has
don't
now
consent
to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You
And-
were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you are
not
going
trying
to
give.
let me ask you a
No, hold
question.
on. I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your attention
you just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you
telling
are
you no
going
such
to
thing.
disregard
I just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Vjerkas says and stands.
What is he wants to inform them that they can do it? Okay, I mean, I don't understand how that's gonna change any of. I mean, you saw during the prosecution's closing argument, they made very powerful statements about he is the one that did this. Take a look at this evidence. We compiled the footage so you can see point by point everything he did. Okay, and now we cut over to Darrell, who just wants to say, hey guys, you have the power to nullify, like, so even if he does this, what does he expect to get out of it? Like, does he just think they're gonna listen to him and do what he... Dude, you ran through a parade and we just watched you do it on video. I don't understand what it is that he thinks is gonna come out of this. And it's like, at this point, he needs to be thrown in the other courtroom. Like, this is getting... It's ridiculous. that he's actually trying to like work this angle of I didn't say I was gonna say that. I didn't say I'm not gonna like.
For the
It's very
proposition that
cartoonish.
although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them
Sir,
merely to be informed.
You can
That's
call
it.
it informing, making them aware.
Yeah, they
Whether
should be aware
you
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction. That's not
because
what I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah,
sir, because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying.
That's what you're saying.
You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
if you
Your Honor,
think
let me
that
finish.
I'm not prepared to deal with an argument on jury nullification,
I didn't say
then
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell
Why was I kept
so
in there?
that my clerk could finish
Adding
the
a jury instruction that was not there.
76 verdict forms, and it's times 2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
or
how
you've
did
interrupted
why did
me
I have
repeatedly.
to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end of last night before you called recess.
I'm not going to debate
we had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court.
Here we
you
go
can
with this.
roll your eyes
Here
at me
because
all
it's,
you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me.
Very true.
But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what
Nice.
lawful law?
Under State versus Anthony.
That it doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the
Okay, sorry to pause in the middle of that. But he believes that a situation has to be exactly the same for it to apply to what's happening right now. I mean, she even said that, okay, it doesn't mention closing argument, but it can still apply to this right now, which is that if he doesn't follow her direction, then he just won't be allowed to give a closing argument, which I'm really hoping that that's the case. And I'm pretty sure that he's hoping that he can do that, and then she stops his closing argument so he can once again cry and say like, oh, do you see this jury? She's not letting me give my closing argument. Like, he's somebody that he feels as if the jury doesn't see or hear what he's doing. He just feels like they only see him as somebody that's being oppressed in the moment. And I feel like he was really like banking on that the jury would maybe see him as somebody that's being oppressed, and oh, the judge is not allowing me to put evidence in, and shackles this and that. I don't know.
Reasoning,
You just said it right there.
nonetheless, is
No.
fully applicable.
No, you
because the more
can't. You can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are. If you're changing, Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So, looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights: waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However,
He is
there is
not
a
listening
second
to any of this.
aspect of forfeiture: doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor.
Oh boy, his best friend is back.
I object to that ruling.
But that
Are
is,
you willing to
I knew he
make
was
a
going to say
closing
that.
argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you
That
just
is so
cited
annoying.
made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at
Come on, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases,
case
Your
from
Honor.
1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be
This is
made
ridiculous.
rules for closing arguments, but not the prosecution. How is that fair? How is that?
Because you are an absolute Fisher Price attorney, you just said a second ago, wow, those are a lot of documents. Well, that is insane. Like, he's the only one that can't follow simple rules. So, of course, she has to put a rule in place to tell you just don't say this. And you know that he's doing this right now because he doesn't actually have a closing argument. There's nothing he can say. The evidence clearly shows that he did what he did. So, yeah, it's just the final clown show, I guess. He just doesn't want to go into that cell. It's ridiculous.
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
That
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for?
He's running through
Matter
the
of fact, I
checklist.
reject that ruling and take exception to that ruling.
Your-
For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is. I'm supposed to be in this admiralty court because you haven't. If we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
He's just making this up as he goes along.
That's a baseless argument, sir. I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also, you're
please
also,
let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
That's right.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your
the
Honor,
issue
that's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why
nullification.
can't they be informed of their power?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury
And I'm
out.
going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Nice.
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've outlined that
oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
Your
All
Honor,
right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Ocker,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction this court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence.
That was wonderfully put by D.A. Sue Opper. She essentially just let Judge Darrell know that you have done all you can to make it clear on the record that this is your stance. And look, she's even saying, hey, he can do it, and I'll just object to that, and it'll be on the record. Like, I do understand she's trying to make things clear on the record just so it's proven that she's not biased like he's trying to say. She allows him his moment to explain his fake problems with this entire process. And I love the fact she sees right through him. She says, we all know he's just gonna say it in the first 3 seconds. Like, you're not, dude, you're not clever. This is all that this is leading up to right now. Like, the fact that he keeps hammering in that he's gonna let them know, it's just leading up to that. But.
And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
Absolutely.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Okay.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury out.
For the record, may I respectfully request the legal reconsideration of your ruling?
Let's just ignore him.
Tacit agreement that you don't have to answer my objection, Your Honor.
I decline to reconsider.
I
Look at the
reject that ruling and
smugness.
take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
I think at this point
For
he's
the
just
record, may
trying
I
to get
respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor.
kicked out.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury's
based on
coming
what
in.
law or
All rise
fact?
for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
Sure thing, buddy. Sure thing. You got it. Of course you are. Absolutely ridiculous. But yeah, I'm pretty sure that DA Suopera is right. He's just gonna say it immediately, and the jury will be
Everyone, please
excused.
seated.
Okay. Let's see the clown show.
Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law.
Okay. And I don't mind pausing in the middle of his closing argument, but what is it that he believes that he can share? Do you hear how vague these statements are? He's not even telling them what it is that they're supposed to be privy to. He's literally just saying it over and over, and I guess that's supposed to make them believe that he knows something that no one else knows. But okay, I just wanted to pause to say that.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
That's clear.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts.
Because you can't.
And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause.
Oh my goodness, this dude is an absolute creep. This is just insane. I guarantee you, he's saying, oh, I have no well-rehearsed speech. I guarantee you in his little cell, he was repeating this to himself. I'm not even sure if I reacted to this before. This seems pretty familiar. He's just gonna do this fake pause as if he's getting choked up, and this is what we're gonna see. Okay, let's go ahead and let this play.
It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit.
No.
In every healing process, there comes a forgiving process. It's not an easy thing for anyone.
Is he really asking for forgiveness right now in the middle of his closing argument?
what you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun. Over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into.
This is ridiculous. Can we just cut him off here?
In my own life, I've had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
This dude is a legit sociopath. Like, he's just mimicking emotions right now and saying random stuff. And it's all about him. Everything he's saying, oh, I've gone through so much in the past year. Like, it's just ridiculous.
While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to.
What is he about to say? This is getting like...
And I'm sure that the prosecution will beg to differ, But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
Improper argument, Your Honor.
Sustained.
Was in fact recalled.
Like, I knew this was gonna be a clown show. As soon as he started, like, as soon as he got this chance, I was hoping that he would somehow talk his way out of getting the chance to do this. But of course, this is what we're getting. But this is disgusting. And he's saying, I've never heard of somebody honking a horn and intentionally trying to hit people, while he actually did do that. It is insane.
Was in fact a class action lawsuit against Ford
Objection.
for those
facts not
model
in evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know.
Because it's not true. You're making this up on the spot.
That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Objection, that is
It's
completely
information-
inaccurate,
it's
Your Honor.
information-
There's an objection. Hold on.
Strike.
Go ahead.
Move to strike statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know.
Wait, you know what? I just thought of something. Maybe, okay, and sorry to pause in the middle, but maybe he'll talk his way into her just abruptly ending this. I didn't even consider that being a possibility. I mean, even though she did just say that that could happen, which is strange. I forgot it, but yeah, maybe he'll just talk his way out of it.
Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to.
My goodness.
DA
What a
says
dramatic display.
the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean
The same rage that he has displayed to not only the jury, but to the entire world as this was being broadcasted. We're all seeing it. We saw the rage. He is hands down, he's probably the angriest person I've ever seen. So this is just, it's crazy that he's really trying this angle like, oh, this was not a crime where I was actually just furious because of what I did to Erica or whatever the fact. Like, it's just insane that he's actually trying to work that angle. As if they haven't seen him on numerous occasions have a tantrum. But they're seeing him throw tantrums like this, and he's acting as if they never saw it. And that they should just believe what he's saying right now. Okay. Sure.
How can you characterize that? How can you have the audacity to diagnose what someone's brain is, where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in?
He's literally mixing everything together.
They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle?
Why did
Because
you
of
run
that
then?
fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature.
So what is he trying to say? Are we imagining that he did that and then they showed a video of him doing it? And so this is all imaginary? But then this is just crazy. And another point I wanted to make really quick. This is proof as to why he's a super, super dangerous person. Because the fact that he's able to flip a switch like this, like, if none of this was on camera, I mean, something of this magnitude, he would have never gotten away with something like this. But he's the type of person to where if it's not recorded, if you didn't see him do like a specific thing, he is able to just lie at the drop of a hat. He feels no remorse about it. Like, he is acting right now. He's doing this whole dramatic staring down at the table and his eyes shifting back and forth as if he's really thinking. And the fact that somebody's able to just do this at the drop of a hat, like he flipped the switch, he started acting. And then we've seen what he's capable of all throughout this trial, the tantrums, the screaming, punching tables. Like, that's what he really is on the inside, but then he flipped the switch. And now he's doing this. This shows why it's like an added layer of danger to somebody like this. And it's something that I was thinking about while I was listening to him talk. I'm thinking like, man, this guy is talking as if he really believes what he's saying right now. And he really thinks that this is how everything went down on that day. And that is just crazy. That's super dangerous. Like, somebody like this, it was inevitable that he was going to do something crazy.
The DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school. to be bullied.
Oh, I remember
For my
this
mother to
part.
have to leave her home and stay at a hotel because she's afraid for her safety. Because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. Haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people.
Don't say it. Do not say it. Don't say for me.
But for everybody involved, the community too. How could this happen? How?
My goodness. I can't. I wish she would cut him off. Just for any reason. Just find some arbitrary reason to cut him off, please. I heard her say something earlier about not appealing to emotion. I don't understand that part, but maybe that. Just find some reason to just make him stop talking. And throw him in the other courtroom, why not? Because more of this is about him saying how it affected him on that day. Even though, and I learned this from you all, that he doesn't communicate with his children really, like he doesn't have any connection with them at all. Okay. I just wanted to stop him for a second because this is gross. This whole time he's been throwing these little tantrums and now he's pretending to be such a caring person and needs to get back to his family. Just okay.
The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that never even I never asked once. Because I know it wasn't.
All right, are we done?
Matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
I really cannot believe it. There you go. There you go. That sums up this entire little act he put on here. It all led up to what he's really trying to say to everybody. Nobody is more distraught than I am right now, that I am about to pay for what I've done here today, or for what I've done here on that day. He's the one that's hurt the most by this, apparently, right? All right, I'm not gonna keep it paused.
So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
For various reasons, right? Not just tantrums.
Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision.
It definitely was.
It's almost like that message, well, not message, but that writing when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
Oh my goodness, wow. That really put it into perspective. I don't understand why he keeps saying you have the power, you and you alone have, like, what do you, I mean, I know what he's getting at. He's trying to tell them to find him innocent, but it's like, it just makes no sense. You have the power, don't forget your power. It's like, okay. Makes no sense, but all right.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
I'm not even going to pause on that one. I'll just, wow.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life.
You know what? I'm going to take a short break real quick. I'll be right back. Because this is just crazy. He's pulling out everything at once. The religion card, the my kids thing. So I'm just going to take a short break really quick. I'll be right back.
Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith.
My goodness, is he done? Is that it?
Look inside yourself.
Oh boy. All right.
Look inside yourself and make the right decision. You have everything in your hands now.
He's not even crying either.
Everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Do what's right. Make the right decision.
He's just repeating the same thing over and over too. These pauses.
It's hard to think about. My younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter. She said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet.
Can you please hurry up and get to what's the point of all this? Okay.
That's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be.
Oh, that's disgusting.
So before I close my statements, just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray and do what you know is right. What you know is right.
It's to the point now where it's like, is this like a threat or something? Like, why does he keep hammering in the you have the power? I mean, he didn't say that right now, but he started it off, have no fear. Like, what is that? Why would they be in fear of finding you guilty or something, like, or because that's what's gonna happen, thankfully, thank God. He's gonna be found guilty, but it's like, at this point, he keeps repeating himself over and over. And then that weird statement at the beginning, have no fear. I don't know. I mean, he might just be acting still, and that's his attempt to try to make them feel like he's a person that is safe or something. I don't know, but he's still talking. I gotta hit the play button because he is still talking, and he's pausing because we're feeling bad for Darrell right now, of course. In the middle of a pause, there we go.
Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. you can live with it.
I'm not gonna pause it. Make sure you can live
That's the
with.
magnitude of the power that you have.
Okay, I said I wasn't gonna pause, but he's basically saying, if you find me guilty, you're gonna feel really bad about this. So make sure that whatever you do, you could live with it. He really thinks that he's like the protagonist in this story, and we're rooting for him somehow. Like in his mind, he's worked it out in that way. But all right.
Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Had no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. And it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one.
This is ridiculous. He thinks this is like his 80s movie moment where he says, I think you all deserve a round of applause, and then everybody starts to slow clap or something. He really thinks that this is that moment. I wouldn't be surprised if he thought that that really was going to happen right there. Okay. All right.
Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Nice. That's finally over.
Before I give the state an opportunity
Thank
to
God.
present rebuttal, please stand for a minute. So please stand.
Thank God that is over. And he's blowing his nose into the microphone. I'll make sure to cut this part out. But yeah, I'm pretty sure I reacted to this part before. I at least remember that part.
All right, have a seat.
Where he
please.
mentioned his
And Attorney
kids
Apparai
and-
did time both closings. You have 13:28 left.
But I did not remember that he said
I
it,
don't think that'll be an issue.
all this nonsense. But okay.
Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered,
Exactly,
that
yeah.
his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones.
Exactly.
I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments, to the extent that your vehicle heaves up and down. Your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Oh, that is amazing. That is amazing. Yeah, I mean, it's nothing to really add on to that. I'm just happy that the entire emotional, like, appeal to the emotions and, oh, my kids, and she just shut all of that down. And I'm pretty sure right now he might throw a tantrum. I wouldn't put it past him that he's probably going to throw a tantrum because of that. Which, if anything, the jury will see, oh, this was fake all along, and this, yeah.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty.
Oh.
You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration.
All right. I can't believe it. This is really it. Like, for some reason, I completely forgot. They're going to actually reach a verdict today, I think, so. Which is in the title, so I don't know why I didn't even
I have a lot of stuff up here.
think about that.
There we go. I counted and recounted 15.
Oh my goodness, I'm excited about this.
So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates,
Okay.
who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I am pulling out is 10. The second number I am pulling out is 30. And the third number I am pulling out is 1. I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure.
You can tell Darrell wants to freak out so bad and say this is unfair. Or what is this creepy facial expression he's making right here?
And I just confirmed that the other 12 numbers were in there. I'll put those back in and then we'll make a record of that. All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration, and I'll go ahead and do it.
Man, this is the big moment. I don't know why, for some reason, I'm actually kind of nervous. We know what the outcome is going to be, but it's just...
Clerk of Court Todd, why don't you join them just in case you're needed? All right, would you all please raise your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with the jury. I do have all of the verdict forms, if I want to get that to Jen.
But yeah, I want to say thank you to everybody for watching all of
Here
these.
are
Like, we're actually at the end.
The jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations.
All right. You can see on Darrell's face he wants to freak out so badly, but he knows if he does it at this point, he thinks there's a chance the jury's gonna side with him, but I think he knows if he freaks out right now, it's just no way.
But yeah, I'm gonna need all of them, and then I'll
Yeah, no, I
take them
know.
down and all
But
that.
those are
But
the-
thank you all so much for tuning into this. I was considering listening to some of the statements from the family members when they come up and speak as well. So let me know if you all would like to see that.
Closed? All right, thank you.
I know that's
You
gonna
may
be
seated.
very heavy.
Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room, and will only be called upon if needed, of course, after consultation with the parties. As far as how late I will let them deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner.
All right.
Anything else the parties would want me to address at this moment
Here we go.
on the state?
The state, thank you, Judge.
Anything from you, sir?
Yep. So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my pod. We only get 2 shower days.
I
a week.
don't, so here's what could happen though, sir.
Jeez.
I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for reckless. 61 injured parties did not testify. So how does that work? How essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law, and I guess that's all I can really say about it at this point.
Okay. I was going to say, I hope they don't allow him to go back to his pod and he gets comfortable and gets to call somebody and everything. But now considering the fact that he's just going to take up this time asking his entire checklist of questions. Like he's starting from the very beginning and he's just going to go through everything. The same stuff all over again. The sovereign citizen stuff. He's just about to ask all of it.
Point though.
I'm sorry?
I got a point though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince the jury beyond a reasonable doubt. For better or for worse, sir,
Please get this off the
With
screen.
any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised, because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming, and I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the...
Oh my goodness, he's doing this weird little facial expression thing. And notice how as soon as the jury's gone, he's right back to his normal Joker-like games. Like, I don't know what this is. What is... Okay.
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on them, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt you.
Thank you, I appreciate that. Unless I would like the parties back in about a half an hour. Thank you, unless...
Great work, Darrell.
Your Honor, do I have to go in that holding cell, or do I get to go?
So happy. We're about to get him in that cell. He's been fighting it tooth and nail, but we're going to get you there. We're going to get you to where you got to be, man. Absolutely ridiculous. And I guess he's trying to be all bubbly now because I guess maybe he's hoping she doesn't find him guilty. I don't know what he's doing, but I don't like it. So we're going to fast forward to when the verdicts are reached, I think. I mean, it's how much longer? Okay, so we have almost 2 hours. So, yeah, I'm just going to fast forward to when everybody comes back, and then I guess we're going to have our verdict. All right.
So I wanted to... Oh, I need my court reporter. I'll wait for her.
Oh, man. Okay, it might be time. It just might be time.
Thank you. All right, it's 7:05.
Judge
We're back
Darrell
on
has a
the
smile on
record.
her face. Let's see.
I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email that the person sending the email had found a post on Justice for Darrell on Reddit, so it's a subreddit. I'm not familiar with how Reddit works, but
What?
and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell.
Dude, that is absolutely ridiculous. There's a subreddit called Justice for Darrell. Look, a lot of people have like different viewpoints and things that they believe in. And so it shouldn't really surprise me that there are like a subset of people that would say, oh, justice for Darrell, even though, like, how gross is that? You saw him drive through a parade. So what justice does he need? But I just looked it up on Reddit. I couldn't find it, so I guess it doesn't exist anymore. But yeah, that's insane. That's just weird.
All those, Justice, the number 4, and Darrell, all, no spaces.
Oh, wait.
I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine, and if, of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted.
I was just going to say, that kind of makes sense that it wouldn't be an actual member of the jury. Just knowing how the internet works, it's probably just somebody pretending that they were actually in the jury. That sucks that the name of the subreddit is so close to the name of my channel. I just now realized that, because I had no idea about the subreddit thing. I'm pretty sure somebody told me about it in the comment section a long time ago, because it sounds familiar. Yeah, that sucks. That's not okay.
So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as it relates to this case in particular.
Darrell's not going to like that.
I hope we have the copies for the parties. And we'll provide those. Go ahead.
I'm making sure you was
Go ahead.
first. What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value and return for value these documents. I'm confused.
At this point, sir, I'm providing the information I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this, I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system, and I simply said, obviously that information needs to go to law enforcement. I haven't seen it, haven't reviewed it, but any person who works in the clerk of court's office who has received an email, that email about this topic will be forwarded to the sheriff's department. Their forensic unit is handling the investigation, to my understanding.
Sorry I'm pausing so frequently, but it's like, it's either one of two things that are going through his mind, or both. One, he is trying to find out a way to say, okay, but why aren't you investigating this right now, because this could be true. So now this shows that you all don't care and you're just trying to put me in prison. Like, that's pretty much the angle I'm thinking he's trying to use, or that he's going to have a tantrum about in a second. But also, Darrell is such a narcissist. I'm pretty sure he's just trying to get more information about his supposed fans, just so he can learn more about that and feel better about himself. So it's either one of those two, or it's both. I'm pretty sure it's both. But.
Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting, and the language is the exact same in all the postings. In viewing the content of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe
that is insane.
A reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Here we go.
Just briefly skimming through it. I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light.
I knew it. I knew this was going to be it.
I will say
he's basically blushing right now. He doesn't know what to say.
Just by skimming through it, these are definitely things that have been talked about in the court. So I mean, common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. There's no other way.
Well, actually,
Because
the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, I mean, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, oh, go ahead, I'm sorry. Something else, Attorney Amber?
A different topic, Your Honor,
Oh,
if
sure,
possible.
go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
Well, I'm willing to discuss that. Do you have any position on that, sir?
Yeah,
He's not done with the Reddit
I would
stuff.
object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room, but that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time, so that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No. I'm talking about a video. We have the ability to play it directly. There's a TV. I should have said that. Probably not too. Why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time.
Okay.
But as far as other exhibits,
So it would be only the exhibits that's been
received.
So
Correct.
nothing new. Nothing's going to come out of the blue and be like, yo, yeah, we're going to.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits,
That's a lot of exhibits.
but I'm willing to have her print it off if you would like it.
I think it'd be helpful just in case. I'm guessing at some point that will come into play.
Right. For example, they may come back and say, we'd like to see Exhibit 15, which is the map, the large map of the parade route, okay? They might want to see the other map. Maybe they want to look at a video. There's a lot of exhibits, so I'm not going to speculate what they want. Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate. That's what the state, I think, was trying to get at. So do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough.
As long as it slows this down, that's all.
Anything else, Attorney Opper?
Yes, we had discussed
That's all that matters.
yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay. Thank you.
Some of that will depend on when it is, if it's
Yep.
late in the evening versus during the day. And you might be wondering, how late will I let...
Uh-oh. What just happened? Okay, it looks like the video is doing something again.
We're done for
Okay,
the
we're back.
evening. They'll come back in. I'll read them the instruction about, they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And they would go, again, where they are being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay. Thank you.
You're welcome. Anything else from you, sir?
Did you talk to the deputies? Or
I
whoever
did. Thank
need
you
to
for
talk
that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But
Nice.
if need be, I'm willing to order that they give you a shower later, if that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're going to stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So I've been
Then I will
told
have
there
to-
is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction.
Subject matter jurisdiction.
Yeah.
You knew I was about to say that.
Sir, I'm not going to address it. I already have. All right.
Just
there
walk
are
away.
requests for 3 exhibit.
I was hoping she'd just stand up and walk away.
Is that his
Let's go to a break.
I know he signed up, but I do. I meant to tell them that. It's a signature.
Yeah, that's always
I need
cool
to
when we
know
get
the,
like a little glimpse
number
behind the curtains of
of
like
the parties who the
how the
foreperson is,
process
I'm not going to
goes.
say the name on the
Hold on.
record. They have a request for 3 exhibits: 15, 5, and 55. Number 11 is the foreperson.
You said 15.
Wait, I'm so sorry. I kind of talked over it a bit. I think the jury may have requested something.
I need to know the number.
Hold on. I'll go back a little bit more. About, wait, no. He's laughing right there. I do not want to hear that. Okay.
Is that his number? I know he signed up, but I do. I meant to tell them that. It's a signature. I need to know the number to tell the parties who the foreperson is, because I'm not going to say the name on the record. They have a request for 3 exhibits: 15, 5, and 55.
Okay.
Number 11 is the foreperson.
You said 15, 5, and
55. So I can pull.
I was gonna say I don't know. I know 15.
15 is the map.
15 is the map. Yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was going to go one by
Jeez.
one. So I'll start with Exhibit 15, which is the map. What's your position on that, sir?
My position.
I don't know what it
is.
This is ridiculous.
At this point, what is the relevancy of the map? I think it's been seen a million times. I know it by heart now. That's probably the only one I know by heart.
Well, what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to work through, and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
Right.
All right, I will send Exhibit 15 back to the jury room. It is an exhibit.
I'm not sure what Exhibit 5
There
is.
really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is Exhibit 5. That is the photograph of Erica Patterson.
Oh, okay.
Oh, I definitely object to that. Seeing as how it was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So I don't even.
What's he even talking about?
It's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one.
Oh yeah, they should definitely see that. They definitely should see that.
I don't even know what I'm looking at if I look at 5.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well, there is an amended information, and I clearly instructed the jury in 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
55. Oh, this is the one with Lola.
15 seconds.
Lola Hospital.
So my inclination, and I'll hear from the parties first, and then I'll give you my inclination. So any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck. We could put it up if you want to preview it, Your Honor.
Go ahead.
And we are requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to we'll verify that the technology is working, and then I would play it for them twice through. And we would watch it at the same time as they're viewing it. Theirs would just be in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it for me. All right, your response, sir?
I know this is going to be crazy.
Yeah, I don't object to it. I guess my objection would be, well, it would be hard to say why the jury would request it.
I mean, that's up to them, right?
I don't know, I'll just let you rule on it. I don't particularly. There's so many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why it would need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date. It is the 25th. My date will be indicated. Obviously, they didn't get the case until today, so it's just a Scrivener's error on their part, putting the 24th versus the 25th. They don't have their technology with them, so I can't really fault them for that. All right.
Any
Madam
reason
Clerk,
why
if
it
you
needs to be played twice?
that's my practice, at least on short video clips. Copy
So
this first.
what about if they request for a long video?
Then I'll make a determination then.
Oh my goodness.
I find that since we have the new technology, it's easier just to do that and play it twice than to bring them out and for them to say stop, and then can you go back and can we watch it again, because that's my experience. So I'm really trying to avoid that.
It's like after watching this for so long, you start to really lose patience with all the nitpicking, him trying to find all these different angles, asking pointless questions about certain things. And like, I was about to pause a second ago because he just said like, oh, all these videos look the same basically. He's running through a look, I'm not going to keep pausing it, but it's like, you guys know why that's an insane statement.
So we'll stay out here, and then
Jen has the warrant.
we'll work to, they'll have to pause their deliberations so we can interrupt them and give them the exhibits, and then make sure the technology is working. So if the state wants to have that ready to go.
All
right.
set for value and return for value these documents, Your Honor.
Thank you.
The suspense is crazy because you know he's going to have about a dozen small problems that he found with this paper. So we're just waiting here. Okay, I think all this happening right now is they're actually watching the videos and looking across the exhibits.
You can turn it off and is it off? All right, the video was played twice. We'll wait and see if they have any other questions.
Your Honor.
Yes, sir.
About this Reddit, is that how you say it, Reddit?
That's my understanding.
This particular person is who the email was sent from, the person at the top of the page?
Do you have the email that has the 9:10 a.m.? That's my understanding, yes.
Were they identified to have any connection with the trial in any way?
I'm leaving the entire investigation in the hands of the Sheriff's Department. I can't answer that. I'm sure they're looking into it though, because that's a good question.
Yeah, this opened up a whole new angle for him to work here. Right at the end, he's going to use this to say like this proves everything. Yep, he's winding up right now. Oh boy. It's like the facial expressions alone are tempting me to fast forward, but I know he's gonna start talking here any second, so I'll leave it alone.
All right, I'm gonna step off. Obviously, the courtroom remains open. And we'll let you know if there are any additional questions. Procedures.
Subject matter jurisdiction, Your Honor.
I decline to address that, sir.
Will we be addressing it for the record?
I wouldn't go too far because it sounds like you want to see it.
Oh, the verdict cannot come fast enough. It can't get here any quicker. Okay, so you guys know the routine. I'm gonna fast forward to when everybody comes back, and I'm sure the jury's gonna have some more exhibits they're requesting, so give me 1 second.
Mr. Brooks?
What's the significance of seeing it as different?
Here we go.
Was that in the question?
They just said, can we see Exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
The significance is the jury's requesting it, sir.
I'm saying at that speed.
It's what they want. They want to get a better look at you, okay? That's exactly what it is. It's so insane that he's thinking like he actually has some kind of authority to say, no, they can't, they shouldn't be able to do that. They should just watch it as is, you know, one time also. Like, none of it makes any sense. Like, this is a trial because we saw what you did, and I'm sure they want to see it at a slower speed just so they can maybe confirm a license plate or just look at something within the video that's more than likely directly shows you in your face. Which is why he's having a little, like, panic attack about it. He doesn't want that to be viewed at all, like at a slower speed, to really see that it's him. Even though we've seen a lot of videos where it's like he's standing still, he's right there in front of the camera, but yeah. Glad this is being granted.
That's their request. I can't tell you the significance for them. I don't want to speculate, but I think it's proper given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask me if I have a position?
Because that's
Oh
what
my
I'm
goodness,
required
dude.
to do, sir.
But you're not required to address subject matter jurisdiction, which hasn't been proven for the record. Not allowed to answer any questions I ask. From your name.
Mr. Brooks, I'm not going to relitigate your case right now.
I mean,
And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
of course it's denied. Of course, because you can't prove it on record. Come on now.
I wanted to make sure.
It has yet to be proven. It has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
Are you ready with the
He's hoping he can cause some chaos here to stop this video thing from happening.
1 second? I just want to play.
I got a feeling he's gonna ramp it up.
Are we doing it once or twice, Judge?
Just once.
Yeah, I don't know what exhibit this is, but
That's
based
40% speed? Yay, nay?
hold on. Okay. I was just gonna say, I don't know what exhibit this is, but based on whatever his reaction is about to be right now, I got a feeling we're gonna know if his face is on the screen. Like, we're gonna know based on how much he freaks out here. So, which I'm guessing he's probably right in the center of the screen or something to be viewed right there. Because he's really freaking out.
The video clip is now ended. Would the state just confirm the speed at which it was just played?
Yes, 40%, Your Honor.
Thank you.
There you go.
All right, let me know if there's another question. The court's going to step off. Obviously, we'll remain open.
Oh, what an absolute cartoon character. That sigh he did right before he started talking, that was odd. Do not like seeing that, but we'll be right back.
At 7:47, the foreperson
All right.
provided a question through the bailiff. We request exhibits 3 and 4. Exhibits 3 and 4 are videos. They are the videos from White Rock, I believe, elementary school, door 1 and door 2.
Yes, correct.
How long are
Wow.
Just 1 second, Your Honor, please.
2 more videos where you can clearly see Darrell.
Exhibit 3 is 4 minutes and 14 seconds. And exhibit 4
6 minutes or something?
is 6 minutes and 58 seconds.
7 minutes?
each? Okay. My inclination would be to play each one time, since they're a little bit longer, and play them one after the other. From the state?
Agreed.
From the defense?
Objection.
Noted for the record. Any specific reason, sir?
Oh my goodness.
The significance of both videos.
Their evidence, sir? And the jury's requested to look at them. So I will be playing them for them. We'll do Exhibit 3 first, and then Exhibit 4 shortly thereafter.
Nice.
Will you be addressing subject matter jurisdiction on the record?
Here we go. Cell doors are closing.
No, I will not.
Is that a judicial determination, Your Honor?
Can you say what started exhibit 3?
I can't. Oh, you're not asking me.
Is that a tacit agreement, Your Honor?
All right, they are ready.
The arrow in the middle of it.
Oh, we can get rid of that. Clear annotation.
Is that a tacit agreement, Your Honor?
Go ahead and play Exhibit 3 in its entirety.
I'm glad we're ignoring them now.
Here you go. You had that one, right?
And there he is. I think he's going to loop back around here in a second. And Erica's going to come back that way.
They're asking it to be stopped. Any objection from the state?
No.
From the defense?
No.
Okay.
That's surprising.
All right. Switch to Exhibit 4.
I think this might be the officer that spoke to Erica. Like after Darrell assaulted her and a group of friends, I think. Unless this is after the parade, I'm not sure. Oh, wait. Also, he's just now coming up. Okay. There's Erica.
They're finished with that one.
Any objection to stopping that video?
No.
All right, Mr. Brooks?
No.
All right, it'll be stopped.
Judge, for the record, this one was stopped at 1:38. Do you know what time we stopped it on Exhibit 3?
35 seconds, I think.
Thank you.
Thank you.
Sure.
Thank you, Madam Clerk. All right, I would think you might want to stay close by.
Was that a good way to reach the state?
I'm not sure
Yeah.
you did, but.
Okay. So yeah, I thought for a second that was like the officer that spoke to Erica after everything had happened. But so okay, that makes sense because it actually is in the area kind of near the parade, so they were probably on their way there. And then here comes Darrell. So okay, I'm gonna fast forward to when we get to the next part. If they got any more questions.
To break for the day, I need to basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room. So I'll read a modified kind of version of instruction 50.
All right, so I guess no verdict for this one. So the next one is definitely going to be the last.
Subject matter jurisdiction.
I decline to address that further, sir.
Will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based in any law or fact?
Hold on.
That is so creepy how he can stare without blinking at all. He's done it like all throughout the trial. He stares forward and does not blink.
I thought it was 2 people that got excused from the jury.
3. There were 15.
No, I'm saying I thought it was 2 from the 16.
No, only 1.
Well, you did say 2. You said one had got excused before, and then another one was getting excused.
No, I only excused 1. We've had 15 since the first juror was excused.
So what happened to that second one that had the COVID scare? What happened with that?
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
No need to
Nice.
get in your feelings. It's been a long day. I'm tired too.
I would agree.
Oh my goodness, man.
But I'm not, I just letting you know I'm not going to rehash that stuff.
I just thought you said 2. You said 2 on the record.
He's like the kid in the back seat that keeps asking if we're there yet. Yes, Darrell, we're almost to your cell. Please, can you give us time to get you there? All right, you keep trying to slow this down because at this point, that's all he's doing. You know, not even at this point, he's done it all throughout the trial. So it's, yeah.
All rise.
All right, jury's coming in. And Darrell threw his mask off for whatever reason. I mean, considering that they just looked at some exhibits, I'm glad he took the mask off. Give him a better look. I'm sure he thinks this is making him like connect with them more, but I'm just glad that they can do that at least.
Thank you, everyone. Please be seated. The record to reflect, I have the 12 jurors who have been deliberating, plus the 3 alternates who were sequestered in a different jury room. I want to give you kind of a modified instruction from the one that you've heard many, many times throughout this trial. Of course, for the 12 who have already started to deliberate, do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow in the jury deliberation room. Do not discuss this case among yourselves or with anyone else until you are deliberating in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. I realize you are sequestered. We've taken away all of those things, but I'm just going to keep reading through this. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I know you're not going home. You're going to another location, but do not discuss this case among yourselves with any other juror until you are back in the jury deliberation room tomorrow. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are all excused for the evening. We'll see you back here tomorrow at 8:30 a.m. All rise for the jury.
All right. And we're just going to see if Darrell has some more questions here. I'm pretty sure he does, but if not, we'll see. Because sometimes it just immediately ends, so.
All right, thank you, everyone. We are in recess. We'll see everyone tomorrow morning at 8:30. 8:30 a.m. I trust that the jail will give you a shower, so whether that's tonight or tomorrow morning before you come back to court.
Definitely.
But I will order that.
In the morning. That's dead. 8:30?
8:30.
I'm not getting up there early. These gotta be some nighttime.
All right, I'm just going to pause it right here. We're not going to hear this. We're not listening to whatever this is. I don't know what he's about to say, but I cannot do this. He's acting as if he's just chopping it up with a friend or something when it's like, dude, go to prison. Just do it, okay? All right, I'm gonna play the rest of it because he might ask something. We got like 6 minutes left, so.
That's when we start court every morning, sir.
No, it haven't been. You did some switcheroo.
Okay, thank God. Day 14, how do I even give a summary of all this? So yeah, basically this was all just Darrell realizing that it's over, and you can see that he has nothing left up his sleeve, which is not surprising. He's basically just running every routine that he's ever tried. But the one thing that I did want to touch on, because I feel like I haven't talked about this enough, the jury absolutely should get a ton of credit, and I just want to say, like, God bless them, because the fact that they had to look at all of this, like, they're people that they didn't experience the parade. I'm assuming, like, maybe they weren't there. They're just people that decided to be a part of this trial, and they watched all of these videos of people being hurt, and they still stayed. They made the right decision at the end, because I mean, you see him in the video, but it's like the idea of having to see all of that, to see all of the pain and the mental strain that is put like on this entire community. They sat through it and then they did the right thing. That is something that I do want to talk about, like, right there, because I feel like I've never done that, or at least I can't remember doing it. So thank you so much to everybody that was a part of this jury, because I haven't even seen the videos of him actually driving through the parade, because I know I could not take seeing that stuff. They've had to see it numerous times at this point. Shout out to them, and they're awesome people. But this is probably going to be a super long video, so I'm going to go ahead and call this one here, because in the next one we're going to have the verdict. So I hope you enjoyed the video. If you did, please like, share, and subscribe. I hope you did something good for somebody today, and I hope somebody did something good for you. I'll catch you all in the next one.